A very good day to each one of you, and thank you on behalf of LAWASIA for joining this webinar on safeguarding the rule of law and human rights in Myanmar. My name is Shyam Divan. Along with Professor Yasushi Higashizawa, I am co-chair of the Human Rights section of LAWASIA. LAWASIA has been organizing a series of human rights webinars both last year and we continue to do so this year. Apart from this present webinar on Myanmar, we will also be having on the 22nd of this month a webinar focusing on the situation pertaining to human rights, justice, and democracy in Sri Lanka. So I will urge each one of you to join and participate in that webinar as well. I thank you all for your time. We have 6 very eminent speakers whom I will introduce in turn just before they speak. We will also have some time for Q&A at the end of this webinar. And I'm grateful to so many of you who've contributed your questions in advance. We will begin this particular webinar with an introductory talk by President-elect Melissa Pang, and I will call on her very shortly to address you. But before I do so, I might just mention that one of the purposes and objects as to why we organized this webinar was that we were interested in knowing as to how we as an association of lawyers and as professionals can help, if at all, both our professional colleagues as well as associations of lawyers on the ground who are in Myanmar, and what we could do to support the rule of law in not just the region generally, but in Myanmar specifically. So with that very, very short introduction, may I request Melissa to please address you on LAWASIA, its activities, and we will thereafter move to the core part of this webinar. Melissa, please.
Thank you, Shyam. Good afternoon, distinguished speakers, ladies and gentlemen. I am Melissa Pang, President-elect of LAWASIA. I'm extremely delighted to welcome you to this important and timely webinar, Safeguarding the Rule of Law and Human Rights in Myanmar. Organized by the Human Rights section of LAWASIA. Today we have over 300 registrants from 48 jurisdictions. LAWASIA was founded in 1966. We are an international voluntary organization representing thousands of lawyers from over 40 jurisdictions, mainly in Asia and Pacific region. It's through our member bar association and peak legal organization, LAWASIA has found its strength. Our policy and agenda directly address issues confronting the professional throughout the region. The spirit of partnership and solidarity among our members' jurisdiction remains our key strengths. As the largest platform for lawyers and organizations in the Asian legal community, one very important aim of LAWASIA is to promote and uphold the rule of law, respect for human rights. Since early February this year, Myanmar has been facing a rule of law crisis when the Burmese military declared a state of emergency and took control of the government. The authorities are waging a campaign to control information. Mobile data was shut down and internet providers were ordered to cut wireless broadband, depriving most customers of access. Over the last 2 months, hundreds of protesters have been killed. Almost 40 journalists have been arrested. and many lawyers have disappeared. Myanmar has been in the limelight. We are all very concerned. We are concerned of their administration of justice, rule of law, and protection of human rights. Today, we have 6 eminent speakers. Especially, we're delighted to have insiders from within Myanmar who can share their first-hand experience and insights. I'm certain you will find this webinar informative and fruitful. On a practical note, we urge authorities in Myanmar to act in restraint and restore peace. We hope to formulate concrete steps to safeguard the rule of law and give a helping hand. Thank you.
Thank you very much, Melissa, for those introductory remarks. I am deeply honored to invite our first speaker, Mr. Kingsley Abbott, Director, Global Accountability and International Justice at the International Commission of Jurists. I am reminded first of a connection between LAWASIA and the International Commission of Jurists, not just at a personal level, apart from anything else. One of our past presidents, Mr. Fali S. Nariman, was a long time member of the International Commission of Jurists. And it was, as a child, I remember receiving those slim volumes of their reports. And it was something which I looked forward to with great interest, because during a very dark period in Indian constitutional history, when we had an emergency, the ICJ really stood up and exposed some of the excesses. Kingsley Abbott joined the ICJ in January 2014. He works under the Legal and Policy Office and is based in the Asia and Pacific Regional Office in Bangkok, Thailand. He has worked for the United Nations as a senior legal officer at the Khmer Rouge Tribunal in Cambodia and a trial counsel in the Office of the Prosecutor at the Special Tribunal for Lebanon in The Hague. He has also practiced as a criminal barrister in New Zealand, where he worked alongside a leading QC, appearing in the District Court, High Court, and the Court of Appeal on numerous matters. I turn the floor over to Kingsley and again express my gratitude for his participation in this webinar. Kingsley, the floor is yours.
Thank you very much, Shyam. I really appreciate the opportunity to be here at this important event. And I do know very well the slim volumes you're talking about of the ICJ. In our Asia office in Bangkok, we have a shelf of them going back to the 1960s and 1950s, and they make incredible reading. I'd like to talk about accountability in Myanmar, because the situation in Myanmar is a direct result of the failure to hold the Tatmadaw to account for its appalling human rights violations. And it's a failure that is shared by Myanmar, by the region, and the international community. Experience from around the world in places like Latin America over many years has taught us time and time again that the situation we are witnessing today was inevitable. Perpetrators who are not held to account for their violations feel emboldened to commit them again, which is exactly what we have seen in Myanmar since the coup and for decades. A brazen, unashamed Tatmadaw killing innocent people on the streets, including children, enforced disappearances, arbitrary detentions, torture, ill treatment, threats to kill broadcast on national television, and so much of it filmed on the cell phones of ordinary people who are forced to face the Tatmadaw alone, resulting in a torrent of footage on social media, and I'm sure in all of our inboxes. Now, there was never any doubt about what the Tatmadaw is capable of. It has been called an army of darkness, greedy, brutal, and unpredictable, conducting clearance operations on multiple fronts inside Myanmar for years. And numerous national NGOs, UN agencies, independent experts, fact-finding missions, and international NGOs have documented the Tatmadaw's atrocities. In 2018, which is now some 3 or 4 years ago, the United Nations fact-finding mission, which looked at representative violations in Kachin, Rakhine, and Shan states, said it very well, and it foretold the future. It began by saying the gross human rights violations and abuses committed in these states are shocking for their horrifying nature and ubiquity. They are shocking for the level of denial, normalcy, and impunity that is attached to them. And Myanmar has a heavy responsibility to remedy the situation as a matter of the utmost urgency, or risk destroying its democratic reform process. The international community also bears responsibility and must take a united stand to condemn the violations and address the root causes. And it says that this begins by ensuring that the perpetrators of crimes are held to account. But of course, this has not happened, and very little has been done at home, regionally, and abroad at the international level. At home, Myanmar's courts were never willing or able to prosecute members of the security forces or hold the government accountable to the rule of law. And despite the work of many, including the International Commission of Jurists over the years on rule of law and administration of justice reforms, such as working on the independence of the judiciary and prosecutors and writs like habeas corpus, those reforms have never sufficiently taken root. And of course, they take time, but that work now is very difficult, perhaps even on hold. And without a strengthened justice sector, accountability at home was always unlikely. Myanmar's laws entrench impunity by ensuring that soldiers accused of serious human rights violations are prosecuted in closed court-martial proceedings, contrary to international law and standards. Judges and prosecutors lack independence, and Myanmar has a pattern of creating committees and commissions to address its issues. An example is the 2018 Independent Commission of Inquiry, the ICOE, that was established to investigate the 2017 clearance operations in northern Rakhine. It still has not released its final report to the public. Its methodology remains opaque, and it had limited powers, and its members showed bias. At a press conference, the chairperson of the ICOE said, "There will be no blaming of anybody, no finger pointing of anybody, saying you're accountable." The whole process fell far short of what is required under international law. In the region, ASEAN has maintained its policy of non-interference over the years and has consistently failed to address the issue of accountability in Myanmar, with member states often playing defense for Myanmar before UN bodies, including the United Nations Human Rights Council. And in reality, ASEAN lacks the political will to push on human rights, the rule of law, and democracy. And you only have to take Thailand, for example, because right now many are looking to Thailand to step in on Myanmar and urge restraint, which of course it should. But Thailand has its own very recent and rich history of military coups and anti-democratic practices. When Thailand's military staged its last military coup in 2014, overthrowing the elected civilian government, it was the 12th coup since 1932. And I was living in Thailand and covering the situation at the time. There was martial law, a flurry of orders and announcements, curbing human rights, entrenching impunity, the jailing of opponents, the undermining of the rule of law. And shortly after the coup, I was privileged to support lawyers to travel around the world back in 2014, warning that if the international community did not hold the line and push back against these developments, a regional precedent of repression and the misuse of the law would be set. And that pushback never really happened, and in fact was sidelined in favor of strategic interests in the region. 3 years later in Cambodia, we witnessed another human rights and rule of law crisis, the worst in its modern history. And again, the world's reaction was muted, and the bar was lowered even further in ASEAN. And now the same strategy is being rolled out in Myanmar in 2021, with all the lessons learned from Thailand, from Cambodia, how to misuse the law to silence dissenting voices, with the confidence that the international reaction will be sufficiently weak as it has been. Internationally, as the fact-finding mission wrote 3 years ago in 2018, and I think this is important to keep returning to, the steps required to address the human rights crisis in Myanmar are well known. There's nothing mysterious about it. But many of the recommendations of the fact-finding mission were not implemented at the international level. It recommended, for example, that the Security Council should refer the situation to the International Criminal Court or create an ad hoc tribunal. It should adopt targeted individual sanctions. It should impose a global arms embargo. And none of that happened. And none of that has yet to happen either. And one recommendation, however, that was implemented was the creation of an independent mechanism to collect, consolidate, and preserve evidence for use in future criminal proceedings or legal proceedings, which brings me to the future. Now, despite everything I've said, the situation of accountability is not entirely without hope. The most critical thing after violations have been committed anywhere in the world is the timely collection and preservation of evidence before it is lost or destroyed. The independent investigative mechanism for Myanmar that I just referred to was created by the Human Rights Council in 2018, and it has a mandate to collect and preserve evidence of violations throughout all of Myanmar since 2011. And the idea is that it will then share that information and evidence with prosecution teams once an opportunity arises, either at the International Criminal Court or somewhere else. And it is watching the post-coup situation very closely and recently made a public appeal for any evidence linking crimes to any particular individuals who perpetrated them or who might have given orders higher up the chain of command. The work of this mechanism will not be easy, but it is now critical to accountability in Myanmar and should be fully supported. Another avenue is the use of universal or other extraterritorial jurisdiction. And the principle of universal jurisdiction, in simple terms, is based on the notion that the fight against impunity is borderless. Under this principle, states have the option and sometimes the obligation to prosecute criminals who are on their territory, regardless of where the crimes were committed or the nationality of the perpetrators or the victims. A case concerning Myanmar, for example, has already been filed in Argentina, and more should be filed elsewhere. And this work under universal jurisdiction is gaining momentum. And we've seen many cases in Europe concerning the conflict in Syria, for example, of actors in Syria now being prosecuted in European courts. With respect to the International Criminal Court, because Myanmar has not ratified the Rome Statute, the International Criminal Court is currently limited to investigating only those crimes where part of the crime was committed next door in Bangladesh, which is a state party to the ICC's Rome Statute. And this is an incredibly important step and a huge pillar of hope for the Rohingya. But until the United Nations Security Council refers Myanmar to the International Criminal Court, which is still yet to do, the International Criminal Court is unable to look at other violations committed around the country, including following the recent coup. And this is why that United Nations Security Council referral is so important. The International Court of Justice we've heard of as well. But likewise, the International Court of Justice case is not a criminal proceeding and is limited to the treatment of the Rohingya and whether or not that amounts to a genocide. It won't lead to criminal investigations and prosecutions, but nonetheless, it is still very important. And both the International Criminal Court and the International Court of Justice will be looking at post-coup events in Myanmar as evidence of the casual brutality of the military relevant to the cases that they are both considering. I'll finish with just a couple of short final remarks. I think critical at this time is to consult with and listen to local human rights defenders in Myanmar and lawyers, to ask them what they need and to support them, and to provide them with avenues of protection where possible because of how incredibly dangerous their work has suddenly become. And also to support accountability efforts, recalling yet again that phrase that we've heard so many times and yet is so relevant to Myanmar right now, that without justice, without a foundation of justice, there cannot be lasting peace. Thank you.
Thank you very much, Kingsley, for that outstanding presentation, linking the rule of law to accountability and how rule of law perishes when we fail to have mechanisms which bring people to account. Thank you very much for that. I'm honored to introduce our next speaker, Ms. Kim Omar, founder and chair of the advisory board Progressive Voice. Kim, as so many of you are doubtless aware, is a true hero. She's the recipient of an award of the Capital Area Peacemaker Award in 1997, Refugee Leader of Promise Award 1997, the Anna Lind Award in 2008, the Global Leadership Award for Human Rights from Vital Voices in 2008, and Young Woman's Peace Award from Democracy Today in 2018. Kin has been working as a human rights practitioner and advocate since 1988, when she began her human rights work as a student activist, organizing a nationwide democracy uprising. As the military regime staged a coup through a bloody crackdown, Omar, along with thousands of other students and activists, left for the Thai-Burma border to continue to fight for democracy in Burma. For the past 30 years, she has lived her life in exile, once in the US as a political refugee, and studied in Massachusetts and worked in the Refugees International in Washington, D.C., till she returned to contribute to democracy movement based along Burma's border, Myanmar's border regions. May I, with that introduction, invite Kin to share her observations.
Thank you, Shan, for your kind introduction. And I would like to say that I am not a hero. I am actually at the disposal in service for my people, for our country, for our people, freedom. And the heroes, the real heroes, are in Myanmar as we speak today, continuing, defying, and resisting this abhorrent, brutal military violence and try to restore peace and rule of law and for democracy. Yeah, thank you for this. But as I was introduced, Progressive Voice, our organization, it's a rights-based research and advocacy organization in Myanmar. We work with a range of local civil society organizations, those who work on a range of issues from human rights protection, human rights defenders, humanitarian aid to labor rights and like environmental protection and refugees' rights, etc. First of all, thanks for having me and also having a chance to join these distinguished panelists as well. First, I would like to also start saying that this the military coup from February 1st, we have to also note that it is still an attempted coup. It is not successful one yet. The military is not successful yet. And it's very simply because the people across the country are resisting and defying. The peaceful protest since right after the military coup has already covered 95% of the country's geography. Coming from the older generation, previous generation who resisted this same military in 1988, I was one of the many organizers of the 1988 pro-democracy uprising. Looking back and comparing the current movement, it's really amazing, like for me, inspirational and very empowering for me to see how the current movement is so vibrant and also involved by all walks of life, but particularly to the surprise, not only to us, it must also be this military junta, is this civil servants, workers from the private and public sectors. They actually initiated this anti-coup movement called the civil disobedience movement, starting from the doctors and nurses joined by the education sectors and the workers. And this is something we didn't have in 1988, which I find also why this current movement is so strong that the military is not successful with their coup yet. Saying that, of course, the violence is so abhorrent. The junta launched a nationwide violent attacks since the day one, building on its history of violence. And now there have been over 700 attacks on unarmed civilians. Killings by these military and police have been in executional style, industrial style killings aimed at the head. And this was publicly announced by this junta. So far, they've killed 598, so it's getting to almost 600 in 2 months, including 48 children and they have arrested over 3,000, including the activist politicians and also the lawyers. The youngest killed was 7 years old, named Kim Yo-chit. Her name means patriotic girl. She was from Muslim community. Before being shot into her stomach, she was scared because her father and brother were beaten by police who broke into their house in daylight. In the past, this military raped and killed women to terrorize the ethnic minority communities into submission. I have met with countless survivors of the military's crimes in the past, including the women who face rape and gang rape by this military, from the Lahu to Kachin to Karan to the Rohingya women in 2017 genocide. Now it appears that they are targeting the children for the same reason to terrorize the communities into submission. The junta has also revived the death penalty and extended a list of so-called crimes to charge and convict civilians by court-martial. Deadliest day of violence was on 27th of March, that over 150 people were killed while the generals enjoyed fireworks and parades in the capital. As you already heard from Kingsley, also there is curfew, there is internet cut. So we have a huge problem of this information shutdown. The martial law is in also some townships in 2 major cities. We have also a problem with this on the civil society and democratic, the civil society sector, because the civil society organizations, even the charity organizations, offices, the media offices are raided, the homes are raided, including in the nighttime and daytime when the people are actually being arrested. Now, more than 480 have been issued arrest warrants, including the celebrities who show their support to the people's movement. New restrictions on local and domestic movement, new restrictions on financial, including the bank accounts of individuals being seized. But also if you look at the ethnic areas where these crimes that we are describing happening in the cities and urban areas have been happening in the ethnic areas of Burma in the frontier border regions for ages. But even to talk about the last 2 months, there were at least 138 armed clashes and attacks on civilians in ethnic areas. But these were related to the prior conflict, resulting in 23 deaths and forced displacement of a few thousands. But since end of March, the junta launched new military offensives in Karen and Kachin states, including the airstrikes, killing the villagers, children, and displacing more than 20,000. And we are expecting more airstrikes are coming into other ethnic areas in the sooner time, because they show their support to the people's movement in urban and city areas. In addition to committing these crimes with the total impunity, including the sexual violence and torture, this military is also getting rid of evidence of their crimes. The injured or dead body were taken away. Next day, the bodies were returned. Their chests cut and patched. In some cases, no bodies were returned. Complete savage behavior. And these murderers are also extorting cash, looting cell phones, computers, motorcycles, and destroying houses, cars, and even the food storage of the people, shooting into houses indiscriminately, setting fires and arsons, all of these things. So now they even form a militant informant group to collect information, make the public threats to the individuals. It's all aimed to further crack down on the movement. And the police are even using the street children as their informants. So yes, there is an absolute lack of rule of law. While the seminar is named to be safeguarding the rule of law, the thing is, we don't have rule of law as an absolute lack of rule of law. And now with this civil disobedience movement, carry on day and night, in spite of so much pressure and threats and challenges. But we're seeing the people with this resilience and defiance using so many non-violent creative tactics and activities, in spite of all of these challenges. But at the same time, people are left with no help from international community to stop this military from inflicting all these abhorrent violence, or to prevent further atrocities So they are trying to defend themselves at the same time, my dear friends. They are trying to defend themselves. Many are in hiding now, running from the arrest, arriving in border areas under the protection of the ethnic armies. But there was already an existing lack of rule of law crisis even before the military coup. And activists and human rights defenders were regularly charged under a whole bunch of repressive laws, even under Aung San Suu Kyi's government. The military drafted constitution protected this military from civilian oversight, especially in terms of the accountability. Complete impunity, committing all of these crimes of genocide against Rohingya and crimes against humanity and war crimes against other ethnic communities. So despite of Aung San Suu Kyi's rule of law mantra, many people in the past 10 years became disempowered during this so-called quote-unquote democratic transition. And this is especially so in terms of increasing inequality, landlessness, and environmental destruction. I'm not going to go much into detail of, but I want to say is that there are many sectors in our country in the past 10 years, in the name of democratic transition and reform. The reality is people are left with higher vulnerability, with no protection from any law as they face all of these different human rights violations from the state. And one of the major problems, the biggest challenge, was also neoliberalization of the economy. And I don't want to go much into that, but I just want to say that if you really count the number of exports and GDP growth, yes, there's been economic success. But if you really count the equality, decent work, and land security, it has been one of exploitation. Myanmar's economic model in the past 10 years has been one that benefits the few at the expense of the countless. The corporate social responsibility policies are merely a band-aid therapy. In reality, they are a bribe to the human rights discourses and not a substantive path towards sustainable development or developing the democracy and protection of human rights. The acceleration of business has not gone hand in hand with the protection of the human rights, especially of the poorest and vulnerable in the society. So yeah, in Myanmar, the rule of law does not exist for the people. It does exist only for the few at the top. So what we really need is a pro-poor, not a pro-business agenda when this revolution succeeds. But see, for now, in the short term, we really need to see this people's movement succeed. And in order for the people to succeed and defeat this ruthless military, we need to isolate this military financially. And the international community is key for this success. We need a Security Council to stop the violence and prevent further atrocities. But also we need them to take the further actions such as those actions Kinsley already described, so I'm not going to repeat it again. But what we need to add on the list is also we need to target like the state-owned enterprises, especially the oil and gas, because this huge cash flow will go into the hands of the military that will be actually used against the people. I think this is so important that we need to actually do that. And I just want to say that, the current movement has called for the targeted sanctions, has called for the boycott of military products. The unions are calling for the divestment. It is not a time for paternalism or condescension. It is not a time to tell the people of Myanmar that their cause to pressure the military economically is bad for GDP growth. Ignoring the calls from the legitimate lawmakers of Myanmar and the people's movement to protect capital interest is a form of neo-imperialism that we don't accept. The people on the ground are risking all, foregoing wages, foregoing their livelihoods in this fight. This is their choice, and they know what is best for them. I hope that you will all support these calls for the targeted sanctions, call for the global arms embargo, and calls for the ICC referral for the justice and accountability. We are going to see very soon a national unity government. I'm not so sure in what exact form it's going to come out, but it has been efforted. The effort is being made by the elected representatives from the 2020 elections, together with the ethnic representatives, including from the ethnic armies. And this is the effort to show to the world that these are the legitimate bodies, stakeholders who are the one who will bring democracy, who will establish the rule of law back in this country. So I hope you will also support their cause. So I will end it here. Thank you.
Thank you very much, Caden, for that perspective. Grim as it sounded, I think you ended also by indicating certain manners in which the international community can contribute in helping restore both democracy as well as the rule of law. Thank you very much for that presentation. Our next speaker is Ms. Vicky Bowman. I'm delighted to introduce her. She served as ambassador of the UK to Myanmar from 2002 to 2006. She has been the director of the Myanmar Center for Responsible Business since July 2013. MCRB is an initiative to encourage responsible business activities throughout Myanmar. The center is a joint initiative of the Institute for Human Rights and Business and the Danish Institute for Human Rights. What is very special is that Vicky is going to address us from Yangon, and she's on the ground, and we had a certain degree of sort of, well, I wouldn't say hesitation, but uncertainty, because we weren't sure as to whether she would be able to join us live. We had a pre-recorded presentation by her, but I'm delighted that she is here before you. And may I draw a call on Vicky to please proceed with her presentation.
Thank you very much, Shyam. I hope you can all see my screen. So I'm going to speak a little bit about the current approaches by business to respecting human rights. MCRB, as you've mentioned, is based in Yangon. I'm currently actually in Shan State in Kalor. And we are a donor-funded organization who has sought over the past 7 years to be a platform for discussions between businesses, civil society, Myanmar government and others. Obviously now we're not speaking to Myanmar government, and civil society groups are very much under pressure, as Kin Omar has mentioned. Just following on from what Kin Omar mentioned, I think it's useful to look at what the Committee for the Restoration of the Parliament, the CRPH, has said around the economy. And it specifically relates to targeted sanctions, as Kin Omar has mentioned. It doesn't call for divestment. And they've also said that there should be a pause on new investments, and that any Myanmar Investment Permission permits issued since the coup will be considered invalid by the democratic government when it comes back to power. So that's what the legitimate bodies within the country are calling for. And I think it's quite important to focus on that. So moving on to what the businesses who are in the country are doing, they are, as MCRB is doing, very much, in the case of at least the ones who are focused on business and human rights, they are using the UN guiding principles as their basic guide to their approach, and that includes the need for ongoing human rights due diligence. Now, what that means in the present state is largely related to the operational risks of continuing to provide services when you have public security forces, both military and police, roaming the cities and towns, as Kin Omar has explained. And by far the biggest risk that businesses face is any form of encounter with these public security forces, either for their employees or for their customers. So we've seen both the employees being impacted by anything from random shootings. There was an employee of a Korean bank who was shot in her commuter bus arranged by her bank last week, but also customers. And there's a case quite recently with one of the banks, KBZ Bank, who had queues of people seeking to withdraw money from the cash point machines, some of whom started to complain about the, and indeed from the bank, not just the cash point machines, some of whom started to complain about the limits which are imposed currently by the central bank. And those complaints were observed by special branch who were hanging around outside. And although the customers were sort of ushered inside and the bank decided to sort of close down and prevent further, or rather just basically protect the customers, shortly afterwards 40 soldiers turned up, having been instructed by the Yangon regional commander to come and so-called arrest the demonstrators. And although the bank said, no, we just had customers and everything is fine, we're dealing with it, they refused to leave until they had arrested those that the special branch guy had observed complaining. So 4 people were arrested and they were sentenced about 2 days ago to 3 years in jail. So these are the kind of risks that businesses are trying to deal with. Similarly, demonstrators who've sought shelter in hospitals, in shopping plazas, have been chased in there by security. So that's led to a lot of shopping plazas closing. And overall, dealing with the internet disruptions, dealing with the overnight curfew, the companies, whether it's providing bottled water or doing maintenance on telecoms, are all really struggling with the current situation to keep their staff safe. We've also seen more, as I think was mentioned by Kinon Ma, in the way of awareness of military-owned companies, particularly in the consumer business, Mytel and Myanmar Beer, something that MCRB has been very aware of since we started, but which now seems to be more in the consumer bloodstream. So I've talked a bit about employee safety, but also employee digital safety. We, and I think many other employers, have been helping our employees understand how to stay safe, given that being found in the wrong place in the wrong time with Facebook on your mobile phone can get you arrested for spreading fake news. And again, 3 years. And one of the brother of one of my members of staff is in that position. We've also discussed with our employees, but with companies, how to support employees who are, or their family members are arrested. This includes connecting them to lawyers, although frankly, the general view is that lawyers are not much use in the current circumstances, because the charges, the sentencing is done in a very inaccessible and opaque way, including inside jail special court. So it's very difficult to get legal support to people who are arrested. And then beyond that, for employees, issues like ensuring that they're paid is becoming increasingly challenging with the banks not functioning. But at the beginning, also, it's important to recognize what employers were doing to enable employees to go out and participate in protests and exercise their right to freedom of expression. And many companies have also been having discussions about the whole question of tax disobedience, both from a company and from an individual income tax perspective. And that's a very difficult one for companies, because obeying the law is, first and foremost, one of the principles by which they operate. And the law is still in effect concerning, for example, the income tax law, the annual tax law, and was adopted by the civilian government last year. Other issues that businesses have been grappling with include the need to try and keep data on as far as possible. At the moment, we only have fiber to the home. Other forms of data are being closed. Banks are really struggling with demands for people who want to get access to their cash, but at the same time, limitations both on shortage of staff and on cash withdrawal. And then they're facing pressure from the military to open branches, but at the same time, pressure not to have queues anywhere near the branches, and having to deal, as I said, with offers of help of security, which they're declining. And then wider challenges relating to how businesses support human rights include the whole question of things like logistics and ensuring that people have enough to eat, have the essential drugs they need, and have electricity, energy. So these are all how businesses are considering the knowing element of their due diligence. Recently, Cognac Create, which is a local consultancy, put out a guide on that online, touching on certain of these issues. The show side of know and show. So we've had a number of statements, and increasingly we're seeing statements by companies of the dilemmas that they're facing around these issues, from companies like Telenor, Total, companies who are also highlighting the difficulties in operating. Woodside, for example, decided to suspend their operations about a month ago, which were in terms of exploration. We're also seeing joint statements by chambers. So I'll just run through a few of these. This is the Total CEO statement, which is one of the most fullest in terms of going through the dilemmas they face vis-a-vis business and human rights. Telenor have also put out a statement concerning their license fee payment, which they made at the end of the month. So all of these are being made in response to the advocacy campaigns around cutting off payments to the government, the state, and obviously Ken Omar is not going to agree with these, and some of my other panelists I know from their Facebook comments don't either. But I'm showing you these because this is businesses who are trying to unpick the business and human rights dilemmas around here. And while it could be easy to say, well, why doesn't Telenor divest? That will leave us with 3 operators, 2 of which are state controlled, and 1 of which, the Qatari operator, is likely to sell itself to China Telecom or another Chinese company quite soon as part of a global deal. Telenor also tried to improve transparency around the instructions that they were receiving from the authorities, but were told and threatened by the authorities not to do this as of early March, I think. So they haven't been able to. But one way or another, they're trying to, all of the 2 operators, Telenor and Ooredoo, who are more focused on human rights, are trying to ensure that the information gets out as far as possible. And one of the big challenges, I think, for telecoms companies, but also for some other companies, is this whole question of when domestic law, and in particular what we see domestic law in the telecoms sector, does not comply with international human rights standards. What should you do? And it's worth looking to the OECD guidelines for their advice on that. So basically honor them to the fullest extent that doesn't place them in violation of domestic law. Now, when you're doing human rights due diligence related to market entry, which many of these companies were doing about 7-8 years ago, you were looking at the nature of the laws, and this is something that MCRB did through its sector-wide impact assessments. And it's certainly the case that I think in most, well, probably in all instances, none of these companies would have come in the current circumstances. But at the time in 2013, although there were weaknesses in the law, there was an expectation that perhaps that these would be improved over time. And indeed, that is something which MCRB advocated for, particularly with the NLD government, to bring the telecoms law in line with international human rights standards, unfortunately, without success. And we're seeing some of the consequences of that now. We facilitated a statement by companies now almost 2 months ago, and at a time before the violence had really kicked off. This was very much focused on companies ensuring freedom of expression and association, and recognizing the value of freedom of expression, not just for civil society, but also for the wider business environment and the rule of law. We have managed to get some Asian companies from Japan to sign up to this, but unfortunately not from China or Korea yet, although I'm still working on that. And I think this reflects, unfortunately, a wider problem that Asian businesses in the region do not really place human rights at the center of their due diligence or how they operate. We've been supported by the Business and Human Rights Resource Centre, who've been trying to encourage Asian companies who are active in Myanmar to respond. There have been a few responses, somewhat lukewarm, I have to say, and not very detailed from Asian companies, but at least they have responded to this approach. And we've seen a few chambers of commerce, but again, a distinct lack of Asian chambers of commerce, with the exception of the Japanese, who have made statements, most recently 30th of March, after the particularly bad violence on 27th of March. And also importantly, saying that they will not meet representatives of the military regime. But that's coming from Western chambers and from the ones that received the invitation, which didn't go to very many of them, because I think that lack of staff at the ministry concerned meant that they hadn't got an up-to-date mailing list. So thank you very much, to give you some sense of how businesses are attempting to navigate what is a really, really difficult situation for the country and for its people.
Thank you very much, Vicky, for that excellent presentation and a perspective from the business and human rights angle. And I agree with you that this is really a dilemma which each entrepreneur has to face. But we do have some guiding posts in the form of minimum standards which corporations must follow. And let us hope that that contribution strengthens the human rights movement. Our next speaker, Matthew Baird, is the director of the Asian Research Institute for Environmental Law. He is just more than a friend of LAWASIA. He is the deputy chair of LAWASIA's Standing Committee on Environmental Law and a member of the International Union for Conservation of Nature and Commission on Environmental Law. He led one of the first training programs on environmental law and advocacy in Myanmar in October 2012 for Earth Rights International, and conducted the Myanmar environmental law training for 40 public interest environmental lawyers in 2013 and 2014, again for Earth Rights, and has remained engaged in environmental law in Myanmar since that time. He has an enormous number of accomplishments in this region. In September 2016, he was appointed as a visiting scholar of the Myanmar Environmental Governance Program of the Vermont Law School. In January 2020, he was appointed as an honorary research fellow of the Myanmar Center for Responsible Business. Matthew, the floor is yours. Please share your views on environmental law and how it's going to be impacted by the current developments in Myanmar.
Thank you, Shyam, and thank you very much to all the presenters. And can I just say that while I thank you for the opportunity of being present today, and to make it clear that my comments are in my own capacity and not as a honorary fellow of the Myanmar Centre for Responsible Business, but I really wish that I was not here. 2 months ago, I was sitting down again via a video link talking about a new environmental law curriculum, working with the Asian Development Bank to establish that in Myanmar. I was working with the My Governance program of the EU, talking about environment, social and governance issues in Myanmar, talking about strengthening public participation, strengthening community engagement, strengthening NGOs, strengthening environmental protection, strengthening the rule of law. And that all changed on the 1st of February. And it must be remembered, when anyone talks about re-establishing law and order or the environmental rule of law or good governance, the simple thing to do is for the Tatmadaw and its proxies to leave and go back to their barracks and start this process working with the legitimate elected government that was elected in November 2020, so that they can take their office in the parliament and they can appoint the presidents in accordance with the constitution. It must be remembered, when anyone talks about opposing views or all sides of the equation, the people that have caused the violence, the destruction of the rule of law, the murderers, and the destruction of the people and aspirations of the people of the country of Myanmar is the Tatmadaw, its proxies, and the illegal, unlawful, unconstitutional coup that occurred after the 1st of February. Other speakers are focusing on some of the elements in that regard, and we've heard of the significant problems being faced by the people in Myanmar. I'm here not as an Australian lawyer, but perhaps as a representative of my colleagues, my environmental law friends who are unable or unwilling to be able to talk about the destruction of the environment and its destruction of the rule of law that is currently occurring. The important thing about establishing the rule of law in Myanmar will require criminals to be prosecuted, such as Senior General Min Aung Hlaing and those who have accepted appointments under that illegal and unconstitutional regime. They must face justice for the crimes and the murders that have been committed in their names and under their authority. So I just want to make 4 specific points. The first is perhaps to pick up Ken Omar's point. The coup has failed. The citizens of Myanmar have repudiated the coup and its failed leadership. Government service is no longer functioning, and the CPRH has made it clear that it will not recognise decisions, approvals, permits made by the junta from the 1st of February. We are in this process of untangling a failed coup, but it must be recognised that it has failed. Secondly, the Tatmadaw and its proxies are now focused on repression and plunder and not governance. The brutality of the repression and their failure to respond to the continual requests by the international community has shown that the Tatmadaw has left the civilized world order and has clearly transformed itself into a criminal enterprise. The commanders and soldiers torturing and murdering civilians have repudiated their oaths to serve the country. Any suggestion that the coup or its proxies represent the official government of Myanmar must be rejected by the international community. The third point is that the international community, especially ASEAN, must support the representation of the legitimate parliament elected in November 2020 and the re-establishment of the rule of law in Myanmar. China, India, Japan, Korea, Australia, and Singapore are significant investors in Myanmar. Unless they support the people of Myanmar, their strategic investments will be reviewed and declared invalid when democracy and the rule of law is restored. The new generation of leaders in Myanmar will not forget those countries who abandoned them in the time of need. Fourth, in order to protect Myanmar's natural resources and support its people, the international community must use all avenues, including the United Nations Convention Against Organised Crime, to freeze all the assets of the Tatmadaw, its proxies and related companies, and the assets of the Myanmar Economic Holdings Limited and the Myanmar Economic Corporation, shareholders, directors, and senior managements. An international embargo on gems, jade, timber, and minerals must be placed on Myanmar until the rule of law can be re-established. Unless stopped, the profits from these enterprises will be used to support environmental crimes and human rights violations. And with respect to some of the comments about the successes or the failures of the previous government of Myanmar, it must be also remembered that the government of Myanmar took many steps under its last mandate to try and reform the jade sector, to reform the gem sector, to reform the timber enterprises. The signing up and the continued support of the Extractive Industries Transparency Initiative showed how these things were working. They were not perfect. They were in process, but that has all stopped. The Tatmadaw has rejected and repudiated all those things that make enforcement and compliance important and relevant. So from my perspective as a foreign advisor who's worked in the ASEAN region for the past 12 years and in Myanmar for the past 7, it is vital that the international community provide no legitimacy to the coup and its proxies. It's important that the international governments and legal community, in particular in ASEAN, reject any attempts by the Tatmadaw and its proxies to continue to murder its citizens, including children, and plunder its national and natural resources for private gain. The Tatmadaw and its proxies must be, including the military-controlled companies, must be seen and accepted for what they were doing and not what they are saying. What the coup are saying is that the Tatmadaw is about stability. What they want is return to an old order that has been consistently repudiated by the people of Myanmar in every election that has been fought, with the exception of the one election where the NLD did not stand. And that has been done since 1988. What the Tatmadaw and its proxies are doing is killing, murdering, burning, destroying, and plundering. These are the actions of a criminal enterprise seeking to use the resources of the state to maintain power. The Tatmadaw has given up any pretense of being able to govern Myanmar. Since the 1st of February, it has ceded controls of many areas to non-state armed actors and militia. It has, in some respects, turned the brutality that has been experienced by many ethnic groups now to repress the majority of Burma areas. The military has moved armed units into the cities. It has abandoned certain areas in the states and provinces. And that has also led to increasing destruction of timber products, the increasing mining, and various actions that are now being used to support the military and its proxies. So the situation going forward is made more complex by the challenges to prevent transnational environmental crime. There are clear reports from Global Witness, the Environmental Investigation Agency, the International Commission of Jurists, and the UN Independent Fact-Finding Mission that show clearly the connection between environmental crimes and the Tatmadaw and the MEHL and MEC. This would be enough to support a freezing of assets pending further investigation. We've already seen the UK and Europe and the USA take action to support the freezing of assets. These are some of the things that should be done by Singapore, in Hong Kong and mainland China, where those investments remain. I should also say that in respect of international companies that may be engaged or connect to such harm, it's important also to highlight two important decisions of the UK Supreme Court that highlight the potential for liability of companies for torts committed in other jurisdictions. Remembering that Myanmar is a common law country, these judgments are highly relevant for actions in Myanmar when the rule of law is restored, or for action against international investments in Myanmar with connections or parent companies or assets in other common law countries such as Australia, India, Singapore, or Malaysia. These cases relate to allegations of environmental harm caused in a foreign jurisdiction by a company with headquarters in the UK. I'm referring to the Vedanta Resources case in 2019 and the Okpabi case against Royal Dutch Shell in 2021, where the UK Supreme Court have made it clear that tort liability was not a closed area. In both these cases, the subject matter was environmental harm and harm to local communities caused by activities of subsidiary companies with headquarters and assets in London. In both cases, the UK Supreme Court held that there was no special doctrine in the tort of legal responsibility in relation to a parent company and the activities of its subsidiary. It was necessary to look at all the relevant factors surrounding those activities. Most importantly for environmental and human rights litigation, the Supreme Court case in Okpabi v. Royal Dutch Shell, it referred to company materials that suggest a corporate supervision, for example, in an environmental related policy or a human rights policy that may not be exercised. In such circumstances, the very omissions may constitute the abdication of a responsibility for which it, the company, has publicly undertaken. The liability for damages in tort in such circumstances may be one of omission for the ultimate head office company. The failure to act in accordance with the group policy on human rights and the environment may lead to liability for such damages. What this means in Myanmar is that Myanmar or an international company or joint venture may be liable for damages caused by its subsidiary company, and a cause of action may be allowed in other countries. It's no longer possible to turn a blind eye to the violations and criminal acts by the Tatmadaw and its companies and associated entities. When damages are assessed, when the rule of law is restored, as it will be, it is important to have assets that can be used to pay for the harm caused by the coup. So freezing of the assets of the MEHL and MEC, its associated directors, shareholders, and senior managers will preserve those assets pending the prosecution of the coup leaders and their proxies. Others have spoken of the human tragedy unfolding in Myanmar. The environmental tragedy is still unfolding. Timber, gas and oil, gems, jade, minerals, wildlife will all become an avenue for profits to fund the suppression of the people of Myanmar. Using existing legal avenues to stop organised crime, anti-money laundering and anti-terrorism is essential. And finally, a comment on the role of ASEAN. The ASEAN Charter, which came into force in December 2008, commits the ASEAN community to ensure sustainable development for the benefit of the present and future generations, and to place the well-being, livelihood and welfare of the peoples at the centre of the ASEAN community building process. And in Article 1 of that declaration, to promote sustainable development so as to ensure the protection of the region's environment, the sustainability of its natural resources, the preservation of its natural heritage, and the preservation of its cultural heritage and the high quality of life for its people. ASEAN has a number of purposes: to enhance good governance and the rule of law, to create a single market and production base, the promotion and protection of human rights and fundamental freedoms, and to promote a people-oriented ASEAN. And while Article 2 of the Charter of ASEAN reaffirms the principles of ASEAN, It includes, but is not limited to, a shared commitment and collective responsibility, non-interference in the internal affairs of ASEAN members, respect for fundamental freedoms, the promotion of human rights, the promotion of social justice, and the upholding of the UN Charter and international law. There is a collective responsibility of ASEAN, and non-interference is merely one aspect of the principles of ASEAN. That collective responsibility of ASEAN is for the protection of the people of Myanmar and the rule of law. And ASEAN must also act to protect the environment and to support the people of Myanmar. There are legal avenues to ensure the protection of the environment, to stop the money flowing to the Tatmadaw, its companies and its proxies, and to set a path for the re-establishment of the rule of law and human rights protections in Myanmar. We must take action now, more than words, and we must use all legal means at our disposal. Thank you for the opportunity for talking today.
Thank you very much, Matthew, for that outstanding presentation and for guiding us to options which are available, not just locally, but also internationally and through probably mechanisms and institutions outside of Myanmar to enforce the rule of law. Our next speaker is Ms. Hannah Lim, Head of Rule of Law and Emerging Markets at LexisNexis Southeast Asia. Prior to joining LexisNexis, Hannah was a corporate lawyer in Myanmar, developing the Myanmar legal practice of 2 Singapore law firms. In her role as Head of Rule of Law and Emerging Markets, Hannah works with the governments to identify areas where LexisNexis can, leveraging on technology, support the rule of law. In doing so, she aims to build meaningful partnerships with key stakeholders in the public and private sector, as well as international organizations. May I call on Hannah to speak on rule of law and her understanding of the ground situation and how we can contribute as lawyers. Hannah, the floor is yours.
Thank you, Sham, and thank you to the LAWASIA team and my fellow esteemed speakers for providing so much discussion on this topic. So I'll be speaking about the rule of law in Myanmar from a practitioner's perspective, since that's my background. As Sham mentioned, I was a corporate lawyer in Myanmar from 2010 to 2017, so for most of the decade of democracy. And then currently in my role with LexisNexis, for the past 2 years, up until the day of the coup, we were working with the Myanmar Supreme Court to enhance transparency for their court judgments. As a matter of fact, we were scheduled to launch a new online system for their commercial cases, to publish their commercial cases on the day of the coup itself. And of course, that event did not happen. Now, the rule of law at its core, and in its most practical and relevant sense, is the mechanism through which all rights and obligations under the law are enforced in what is to be a fair, transparent, and effective manner, and by an independent judiciary. It is fundamentally a type of machinery, infrastructure, that ensures that our legal system functions in a way that upholds our core values, including that of the protection of fundamental human rights. And I concur with my fellow speakers today, and any observer will tell you that the machinery of the rule of law does not exist in Myanmar at this current moment in time. The events leading to the taking of power from the civilian government were unlawful and a clear violation of the constitution, despite the junta's claims otherwise. And since then, thousands of people, including prominent leaders from the NLD, have been arrested on spurious charges with limited access to lawyers. Now, we haven't seen, and at least I'm not aware of, any coordinated response by local bar associations or other law associations, either at the national or state level. Instead, we've been seeing individual lawyers, of course, bravely stepping forward to defend victims of such arrests at police stations. And in doing so, they risk their own lives and liberty. The bravery of these lawyers in Myanmar and their commitment to the values and duties of the profession is truly inspiring. And as already described by my fellow panelists, the military self-styled government is now amending the laws in a way that weaponizes the law against its own protesters. And when in doing so, while at the same time, their own forces continue to commit crimes while covering up evidence of such crimes. Such abuse of the law has led protesters to declare that when injustice becomes law, resistance is duty. But all of this are just symptoms of the underlying reason of why the rule of law does not exist in Myanmar today. And that reason is simply that the Myanmar state has become incapacitated as a result of the failed coup. In order for the rule of law to subsist, there must be an effective sovereign entity that has both power and moral authority and legitimacy over all other legal subjects in its jurisdiction. So in our world today, the rule of law can only be established by a state. And in Myanmar's last decade of democracy, the Myanmar state did make some progress in advancing the rule of law. And I agree that it was imperfect progress and uneven, but there was at least some hope that we were getting somewhere. As a practicing lawyer, I observed an evolution in how businesses approached the law. In the early 2010s, the law at that point in time served no meaningful purpose and was just another nuisance to be managed by foreign investors, like electricity cuts. But as the overall legal environment improved, businesses started taking the law seriously, and we saw the growth of demand for business lawyers and the fact that people started to pay attention to what was in their contracts. And later in my current role, I observed enthusiastic and genuine efforts by various justice sector government institutions to enhance transparency and access to justice by improving their systems and processes. While the purpose of my project with the courts on paper was to improve the ease of doing business rankings, the officials I spoke with would often tell me that it was also for justice. So all this progress was slow and uneven, but there did remain some possibility of building meaningful rule of law in the last decade. And now we are, of course, witnessing a setback in this journey because the battle today is over the state itself. And with this coup, the military has fragmented the sovereignty of the state in relation to its legal subjects. So now there is no single institution in Myanmar today that concurrently has both power and the moral authority necessary to effectively establish the rule of law. So those are my observations on the current state of the rule of law in Myanmar. And I would now like to offer some thoughts on safeguarding this institution that has been suspended. Because while the state is necessary to the rule of law, on its own, it is insufficient. And the state has always relied on other non-state actors, and particularly lawyers, in order to support the rule of law. And further, it would be too late for us to wait for the battle of the state to be resolved in order to talk about defending and safeguarding the rule of law. This is an emergency, and the legal community needs to respond appropriately. So I'd like to suggest two things, if I may. First, whatever we can do now to ensure that justice will be served in the future or through international forums must be done now and with urgency. As Kingsley and Matthew have noted in their previous discussion, holding those who commit such crimes to account is of utmost importance if we do not want to see this happen again or elsewhere, because injustice anywhere is a threat to justice everywhere. But doing so includes, for example, carefully documenting evidence as they unfold, collecting and safeguarding reliable evidence for use in later trials. And this was a point that Kingsley has also raised earlier on. And the requirements for pictures and videos and other types of evidence to be admitted as evidence before a court of law are not always clear, and this information does not come intuitively to everyone who sets out to record events that are happening around them. And what lawyers can do and should be doing would be organizing, facilitating, and sharing information on how best such evidence should be collected, managed, and stored. And there is also technology available to support this. And if you're interested, you can Google the Eyewitness to Atrocities app. It is a useful example of what tools are out there. So that's the first point. And the second point is that if our legal institutions no longer function, lawyers have to step up to influence, guide, and inform the actions of the community so that the community is not itself at risk of infringing fundamental human rights and the shared values that the original legal system was established to protect. This is a particularly important point right now as the resistance in Myanmar is considering taking up arms. And this may appear to be a daunting task, but I'd like to suggest that this is the essence of our legal training as lawyers. A former Harvard Law School dean, Robert Clark, once described lawyers as being specialists in normative ordering. We are trained to handle the rules and norms that define the rights and duties among people and organization. So all the work that a lawyer does, in essence, is to create, find, interpret, adapt, apply, and enforce rules and principles that structure human relationships and interactions. And this skill of normative ordering becomes even more important in the absence of legal institutions that would be guiding human behavior in normal times. So that when resistance must become duty, it is the lawyers that must help the community make sense of this duty in a meaningful way. Duty to whom? What does this duty look like? And how do we fulfill this duty of resistance while safeguarding fundamental human rights? And we need wise and strategic counsel to guide the responses and actions of the resistance in a manner in line with our values, and particularly with the purpose of protecting fundamental human rights. And these are actions that can be taken even if the rule of law is suspended. Because as legal machinery, the rule of law is a means to an end, the end goal of justice and the expression of our shared values. So in times such as these, we have to find alternative ways of fulfilling that end goal using stopgap measures, while at the same time working to restore the rule of law wherever possible. And when we do so, lawyers would be protecting the integrity of the resistance so that the state that eventually emerges from this battle can be a true reflection of the hopes and expectations of the community and the values that is expected to embody. And this is essential if the state is to command the moral authority and legitimacy in the eyes of all its people, including the ethnic minority groups. And this is required in order for it to credibly establish the rule of law for everyone and not just for the few. Now, all of this requires not just the lawyer's skill of normative ordering, it also demands a deep understanding of the power structures that stand in place of the rule of law. Because the absence of the rule of law is not simply characterized by absence. There will always be something else in its place. Something will rush in to fill that vacuum. So to be effective in defending our legal institutions and in guiding community action in the absence of such institutions, and then finally to contributing to defining and rebuilding these institutions, we need to know what we're up against and where our starting point is. So when the state is incapacitated, it is incumbent on us lawyers to be resourceful, creative, to take quick and decisive action and not to give up hope. And it is particularly incumbent on the international legal community to provide as much support and protection as they can to lawyers on the front line. So in times like these, lawyers can be considered as legal paramedics and first responders. Because when there is no rule of law, then practically speaking, all we have left is each other to rely on. So thank you very much for this opportunity to speak.
Thank you very much, Hannah, for that presentation. I loved that last characterization of yours of lawyers as legal paramedics in a situation where the rule of law has been completely denuded. Many, many thoughts and points which we will carry away. Thank you very much for that. Our final speaker is Dr. Jonathan Lilleblad, Senior Lecturer, Australian National University, College of Law. Jonathan received his PhD and JD from the University of Southern California, an MS from the University of Washington, and a BS from the California Institute of Technology, Caltech. His research largely focuses on rule of law with case studies from human rights and environmental issues. His fieldwork is mostly in Myanmar. Generally, his research falls within the fields of international law, rule of law, human rights, environmental law, law and development, and law and society. He was born in Myanmar, but grew up in Sweden and United States. He was a Fulbright Scholar in 2014-2015, and he's currently working on projects supported by the International Commission of Jurists, the Danish Institute of Human Rights, and the United Nations Development Programme. Jonathan, I'm sure the entire audience, but I in particular am very anxious to hear your contributions. The floor is yours.
All right, thank you. So my presentation follows closely with the comments of Matthew and Hannah, and the presentation is not meant to be facetious. As much as I have an American law degree, I'm taking a slightly different perspective than the previous speakers. My PhD is in international relations. And because of that, I'm very cognizant of the realities that exist in a region like Asia. And specifically for those of us coming from Southeast Asia, We have grown up with the reality of living with authoritarian regimes that are run by strongmen, and specifically strongmen that are averse to notions of human rights and are very reluctant to accept international interference. And so very much like Don Corleone in The Godfather, they're very much focused on maintaining a family of ASEAN states and maintaining a family business. So in following that kind of logic, I speak to you today as a consigliere, and a consigliere that specifically is providing suggestions as to how you can work through the internal logic of the strongmen, and specifically try to rationalize through the internal logic of the strongmen to make them see that at minimum, they need to take action to protect the family business against what I consider to be the growing problem of the bad brother that is within the family. And that's the bad brother represented by Myanmar or Burma. So just to supplement the information that Matthew provided, I'm showing you here a list of links. These are sources that have conducted the research that has demonstrated the links between the Tatmadaw and black money and white money operations. So white money operations, Matthew had indicated, were the business enterprises such as Myanmar Economics Holdings and Myanmar Economic Corporation. What Matthew and Hannah did not mention is that the reason why these kinds of transnational business conglomerates are so important is because the dividends and the shares are held directly by the Tatmadaw or the Myanmar military units, and also held directly by the Myanmar military generals. And as a result, a lot of the international business partners that do business with their branch offices in places like Singapore, Bangkok, Hong Kong, Seoul, and Tokyo are invariably supplying money that's going directly to the military rather than to the business enterprises. The other thing to note with these sources is that they also indicate that the Tatmadaw links go beyond white money and they go to what we call black money. So this is specifically the transnational criminal activities, and history and historians and scholars have noted that the Tatmadaw is involved heavily in drugs. So heroin, opium, methamphetamines. They also have activities in human trafficking. Matthew had mentioned the gemstones, timber, wildlife, but the other thing to mention also are the illegal weapons. Something also that security specialists note is that the Tatmadaw is also linked to the Buddhist nationalist movement in Myanmar. So most of you do not know that Mabatha, the extremist Buddhist entity that became famous or infamous in 2015 to 2017 with the Rohingya crisis, was comprised largely of monks who were military veterans, and that their activities were financed by the Tatmadaw. Now, the thing to note here is that by linking the black money with the white money operations, that the problem that's represented by the Tatmadaw has never been internal. It has never been internal. In order to generate the kinds of revenues that are necessary to further their interests, everything is transnational. So it's transnational drugs, transnational prostitution, transnational crime, transnational mafia, transnational money laundering. And with the extremist Buddhist movements, they've also made alliances with comparable Buddhist extremist movements in Sri Lanka, Thailand, and Cambodia. So that's now extending into transnational terrorism. Before 2021, before the coup, most of Southeast Asia treated this phenomenon as manageable. I think most of the strongmen and authoritarian regimes in ASEAN were willing to look the other way. However, with the coup, we're now dealing with a situation where there is a growing risk of an escalation, a dramatic escalation of these kinds of activities. Either scenario that we are foreseeing playing out, either if it's proxy war or civil war, risks engendering large refugee flows. So if you know, the journalist reports regarding the increasing involvement of Russia, China, et cetera, whoever is involved, that if there is a proxy war, that's going to drive refugee flows. If the journalist reports are right, and that there is a growing resistance movement with an alliance between the ethnic armed organizations and the civilian government, that also means a civil war, but that also means refugee flows. So in 2017, 2018, the refugee flows involving the Rohingya involved anywhere between 600,000 to 800,000 people crossing the border into Bangladesh. If the refugee flows go nationwide, we're also then talking about comparable numbers going into Thailand, Laos, Malaysia, and then if they're going by boat, potentially going to places as far as Singapore and Indonesia. So these numbers then would go from being 600,000, 800,000 to being in the millions with the consequent attendant issues regarding transnational crime, laundering, as well as transnational terrorism. So this is, as a result, the ASEAN family is dealing with a bad brother problem. Now, within the internal logic that we hear so much within ASEAN states is that we see the language of rule of law and non-interference. So rule of law is normally justified and linked to concerns over stability, harmony, the need to protect society. Increasingly also with one of the pillars of ASEAN is in support of economic unification or economic regionalism, sorry, that there's a need to maintain investor confidence, particularly international investor confidence. And then along with the other pillar, with the rest of the international community, a concern about trying to stop terrorism. On the other hand, there's also this desire for non-interference. And so this translates into an aversion to physical intervention in another state. It also means an aversion to international peacekeeping operations in another state. It means an adherence or a commitment to always work with each state working within its own jurisdiction. And that if there must be any kind of regional activity, it always must be done through a process of consensus. Within the logic of the strongman and strongman politics, within the logic of the family business, my comment here is that ASEAN has historically always been about telling the world that there is nothing to see in Myanmar. There's nothing to see, and that ASEAN will take care of its brother. What happens if the brother is a drug addicted schizophrenic with an anger management problem? What happens if the brother is someone who's also subscribing to an apocalyptic Buddhist cult? What happens if the brother has friends who start to interfere in the larger neighborhood? What happens if the brother is engaging in activities that's scaring away the international customers? What if the brother is engaged in activities, drugs, prostitution, crime that is affecting your kids, your children? What happens if your brother isn't telling you the truth about what the brother is doing? You know, so for all the strongman politics that plays out within ASEAN, my question is, do you let your brother do what he wants, even if it means the downfall of the family business? So these are my suggestions from a consigliere perspective, that even within the logic of the strongman, that there is still room for movement, room for action with respect to the bad brother problem posed by the Tatmadaw. And it is entirely consistent with the arguments about rule of law and non-interference. The simple matter is just do what you do. Just do what you do as authoritarian states. You act within your jurisdictions, you follow your arguments regarding rule of law. So what does this mean? Well, we know who should be the focus. The research has already been done regarding the domestic partners that are affiliated with the Tatmadaw business enterprises. The research has already been done to identify the Tatmadaw branch business offices that exist in different ASEAN countries. We know what is needed. So within each state within ASEAN, there is a repeated statements about the interests of stability, harmony, and society. So this tells you that as a simple matter then of going through the domestic business partners involved with Tatmadaw branch businesses and review them for criminal activity, for links to criminal agents, to take actions to maintain and ensure investor confidence and investor concerns regarding money laundering, global accounting standards, embezzlement, graft, to also address international concerns regarding terrorism and to check for links with terrorist activities. How we do this? The laws in most ASEAN states already exist. There are already laws that have been enacted regarding due diligence regarding business enterprises. There are already laws that have been enacted regarding the preservation of evidence. And so it's a simple process then of just checking legal registration, tax audits, bank transactions, etc. In terms of preserving evidence, this also means things like suspending transactions, bank accounts, corporate assets, financial statements. Note the word here I use is suspend, not confiscate. I know that within ASEAN, there is a reluctance to do anything that might be construed as confiscation or seizure, but it is very consistent regarding the rule of law arguments to just simply say that you are suspending things to preserve evidence for further review. One thing I will also note, and this is regarding to my comment about, does your brother tell you the truth? So what I'm showing you here is a textbook that was that existed during, it was issued by the Tatmadaw under the military regime. It was used as recently as, my understanding is 2014, 2015. So this is the Myanmar Yodia history manual that was used within Myanmar schools. And this is basically the Tatmadaw history of Burmese relations with Thailand. And in this textbook, it essentially argues that and highlights the fact that the Burmese civilization conquered the Thai civilization and that the destiny of Myanmar is once again to dominate. And it refers to the historical acts between the Burmese civilization and the defeat of the Thai armies in history. And so I know that as much as many authoritarian regimes, particularly military regimes, would see or look upon the Tatmadaw as a kindred spirit, please be careful, please be mindful. Your brother is not always telling you the truth. You always have to watch behind your back and be concerned about what your brother is really saying about you. All right. So again, I will finish with that. My presentation was very brief. And I was just, once again, dealing with my frustrations, with what I've heard from so many ASEAN states about the ASEAN way and the ASEAN way of dealing with things and how that justifies passivity. And what I'm trying to present to you is more of a political argument that you can respond to those kinds of perspectives using the internal logic to address what we consider to be ASEAN family matters. And so I'll stop my presentation there.
Thank you very much, Jonathan, for that presentation and for describing to us as to how entrenched the military is. And so quite apart from building new institutions for safeguarding rule of law, I think there is obviously going to be a necessity to dismantle some of the structures which are so deeply entrenched in Myanmar if rule of law, justice, and democracy are to have any chance. I wish to thank first and foremost all the panelists for their outstanding contributions. I leave this webinar greatly enriched from their perspectives and their sharing. I thank each one of you as a member of the audience for having participated in this webinar. I must share with you a couple of points. We had a bank of questions from participants, and I circulated we circulated that bank of questions to our esteemed panelists. You'll notice that many of the questions were sort of woven into the presentations, the answers to their questions and their perspectives. And therefore, there is no real need, as I see it, to address a few of, to put these questions to individual panelists, because they've been good enough to respond to them in the course of their presentations, and I thank them for that. That said, I also noticed that there are a few questions in the question box. We are running out of time. I noticed a couple with respect raised by Jeff Leong regarding the LAWASIA response. I think the purpose of this webinar was to try and bring forth various views and help us calibrate a response as to what we can do given our capacity and resources. So we will digest the suggestions made by the eminent panelists, and we will place them before the executive committee of LAWASIA. I might also add that we had in the past, since it was suggested, will LAWASIA set up a fact-finding sort of a committee or a task force. We had during the Rohingya and the Rakhine crisis, which continues, set up such a force in the past. But we found that the situation on the ground, even though we tried to engage, was very, very difficult. And so an institution like LAWASIA found that avenue difficult to pursue. But I think there are a number of suggestions which have come forth in terms of strengthening rule of law. And I think we will deliberate on these, and we will act in furtherance of what we can realistically manage within our resources. I again thank each one of the panelists. I urge each one of you in the audience to consider becoming a member of LAWASIA. And regardless of whether you're a member or not, we have a very eminent panel, again, equally eminent, coming up on the 22nd of April, where we're going to be discussing the situation on democracy, rule of law in Sri Lanka. And I urge you all to join that webinar, which will be on at the same timing, except that it's going to be a couple of Thursdays away on the 22nd of April. With that, I thank you all for your time and have a very good day. Thank you.